Okay, so today we're going to talk about, I'm not going to keep trying to get it to get rid of the sidebar. That's what's been driving me nuts. So we're going to talk about legal duty to disclose. And this is actually mentioned in several different places in not only our statute, but in our contracts, in our listing agreement, and it's the law on many levels. So I just wanted to make sure that everybody understood legal duty to disclose, because this is now and has been for years a big common misunderstanding about what our duty and what a seller's duty is to disclose. And there's a lot of misinformation out there. So what you're looking at here should be, it should say seller brokerage engagement agreement. And this is also known as our listing agreement. This is a snippet from the paragraph on seller's property disclosure. And so when your seller signs a seller's brokerage engagement agreement, whether it's exclusive or non-exclusive, they are consenting and acknowledging that they will disclose any known latent, aka hidden defects with the property. And it says here where I've highlighted that this is a statutory requirement. It's Georgia Statute Title 51, Chapter 6, Paragraph 2. And it says that the seller agrees to disclose even if they're selling the property in as-is condition, because as-is does not ever absolve somebody of their duty to disclose. So that's actually in the listing agreement. And then it even lists the different seller's property disclosure forms, the F301, F304, F307, and then the short form, which is the F302, which is just the minimal form that a seller would need to fill out to disclose any known defects. Examples of that would be things like unpermitted work. That's actually a question in the seller's disclosure statement. Are there any improvements that the seller has made or that the seller knows were made that have not been permitted? That's a big deal right now with a lot of investors and flippers and stuff, is unpermitted improvements. And we're going to talk about the fact that if you guys are aware that there is an unpermitted defect or unpermitted work or known defect or anything of that nature, you have to disclose it as well, because this is all about protecting the public. It doesn't mean the seller has to fix it. It means they simply have to disclose it. So below, in the next box down, you'll see where I have the statute that is referenced in our seller's disclosure paragraph in the listing agreement. You'll see the actual statute. This is Title 51, Chapter 6, Paragraph 2, and it says, when misrepresentation of material fact actionable as deceit, effect of mere concealment, knowledge of falsehood, essential to deceit when knowledge is implied. It's basically saying the willful misrepresentation of a material fact made to induce another to act upon which the person acts to his injury will give him the right of an action. So this is enforced through litigation. And it says here, in all cases of deceit, knowledge of falsehood constitutes essential element of a tort. Tort is defined here at the bottom as a wrongful act or infringement of a right leading to civil liability. So when it says other than under contract, that simply means that if somebody is aware and they're agreeing to something, then they're not being harmed. But if they're not aware and they're not agreeing and it's being kept from them, that gives them grounds to file a civil lawsuit. Any comments or questions so far about this? This is, again, what sellers are agreeing to do when they sign a listing agreement. And we, as their agents, have to educate them on this. Okay, let's look at the next slide. This is GAR CB10, which is the consumer brochure. CB10, protect yourself when selling real property. This is a fact sheet, 3-page educational document that you should be giving to every seller that you represent. Very, very, very important. It goes into all kinds of wonderful advice for sellers. But right here on the first page at the top right, the GAR attorney that wrote this discusses understanding their duty to disclose. And this is speaking to sellers. And it says here, you cannot avoid disclosure obligations by selling a house in as-is condition. Known hidden defects must be disclosed. Has any of you guys, this is kind of a rhetorical question, have any of you guys ever heard of a listing agent or seen somebody advertise as is, no disclosure, or anything of that nature, or implied that because something's being sold as is, or maybe that it's investor owned, or that the person never lived there, et cetera, that somehow they're exempt from disclosing material defects or knowledge that they most likely have? Have any of you guys ever experienced that?
Yes.
Well, this is what I'm screaming from the mountaintops, that this has never been correct. And, you know, most of you guys have taken classes with me before where I've talked about rule number 1, don't take advice from other agents. And that's largely what I'm talking about. Don't take advice from other agents, meaning don't assume that what they're saying is correct, and certainly don't do what they do, because as is and disclosure have absolutely nothing to do with one another. You also don't want to break rule number 2. Rule number 2 is don't take advice from customers and clients. So when you have that investor, or you have that person that's saying, oh, I don't have to disclose because I never lived there, or I don't have to disclose blah, blah, blah because of this or that and the other, it's an investment property. None of that matters. They either have knowledge, and the knowledge they have, they need to disclose. And as a matter of fact, it is the smartest thing they can do to protect themselves from a successful lawsuit. So if you have knowledge that there is something, you know, that has a defect of some sort, and that includes unpermitted improvements, you have to disclose. And we're going to look at that in just a moment. You, the agent, have to disclose, because we're opening ourselves up for liability of being sued and or penalized with the real estate commission if we don't disclose. So if you're aware, you have to disclose, and the seller needs to understand that as well, that if you're aware of something, in order to protect the public, you legally have to disclose it in writing. And I'm fine with you guys sending an email as long as you can document that you disclosed it and the source of the information, then that's perfectly fine. You can prove you disclosed it to the buyer or the buyer's agent, whichever the case may be. Then that is protecting us. But the sellers need to understand that defects such as unpermitted work or leaky basements or foundation issues or flooding issues or things of that nature, or even drainage issues in the neighborhood within a mile radius that no one would know about unless they live there, sinkholes, etc. All of those types of things that once you are aware of them, if the seller has not disclosed them in writing, you must. So it's very important that our clients be educated on that.
Angie?
Yes. I heard my name.
Yes, this is Tammy.
Hey, Tammy.
How are you?
Good. How you doing?
Good. I just have a quick question about if you were under contract and you received during your oh gosh,
Inspection.
I'm drawing a blank. Yeah, your inspection period,
Yep.
but they declined to provide the inspection report, but they just asked for certain things based on that report. I mean, you never saw that proof of it, but you know, your contract terminated because you couldn't come to terms. Is there anything you feel the need to disclose, but you never really knew about it before based on that?
Technically, here's the deal, and that's an excellent question. So here's the language in our purchase and sale that says right here, Tammy, that says notice to a broker, or it says actually seller has a duty to disclose, and this is in the inspection paragraph, inspection and due diligence. And it says seller has a duty to disclose even if the property is sold in as is condition. In this next paragraph here, that's your notices that says even if somebody delivers something to you and it's not opened by the recipient, it's still deemed delivered, and delivery to you is considered delivery to your client. So let's say that they are and Beretta, which is what we, as brokers and agents, get sued for. We're going to look at that next. Beretta doesn't make any exceptions for verbal. So whether they sent you a proposed amendment without the inspection report, or they sent you the inspection report, you're deemed to have gotten it once it hits your inbox. So you need to open it because you're responsible for its content. So is your seller, because it's deemed delivered to them when it's delivered to you. But let's say, just to kind of emphasize this, that they only sent you an amendment with request, you still been put on notice that there's a problem, that they're asking for it to be fixed, even if they didn't give you the detailed report. Let's say they didn't even send you the amendment. They just verbally negotiated, and they notified you that there's a problem with the hot water heater and they want the hot water heater replaced. So there's a problem with the HVAC and it's not cooling properly, and whatever it was. Regardless of the way that you've been given this information under Beretta, which is what we get sued for, you have to disclose that information that has now been given to you and the source of it. So you would have to say to a future buyer, this is what happened. This is what they were verbally asking us to do. They never gave us a report, but they were alleging that there was something wrong with the HVAC. This is what they said. This is what they were asking for. We couldn't come to terms. You have to not only disclose it and document that you did so in writing, and an email is fine, or you need to actually will disclose it and give them the source of the information. So that would have been the buyer's agent. Does that make sense, Tammy?
Yes, thank you.
Yeah, no problem. Anybody else have any questions about the notice and delivery of notice? This is again from our purchase and sale agreement, or duty to disclose, even if it's as is. Okay. Let's go down and look at Beretta real quick. And Beretta is, just for those of you who aren't familiar with the term, Beretta is the Broker Relationship and Real Estate Transaction Act. So here we go. Beretta is enforced primarily through litigation. However, if you violate Beretta, and again, this is Georgia Statute Title 10, Chapter 6, Paragraph 5, and it is duties and responsibilities. It has several different segments, but the one I've got highlighted here is the duties and responsibilities when you're engaged by a seller. And it's primarily enforced through civil litigation. So this is where brokers get sued because they've been negligent and someone is harmed by their failure to disclose, for example, or their being deceptive or withholding pertinent information that somebody really needs to know. Beretta actually talks about here in Section B that the broker representing a seller has to disclose all adverse material facts pertaining to the physical condition of the property and improvements located on such property, including but not limited to material defects in the property, environmental contamination, and facts required by statute or regulation to be disclosed, which are actually known by broker, which could not be discovered by reasonable diligent inspection of the property by the buyer. For rule of thumb on that, let's not split hairs. If somebody can't literally see with their own two eyes, then that it needs to be disclosed. And so just when in doubt, when it comes to material defects, when in doubt, disclose. Just that's absolutely rule of thumb. It goes on to say all material facts pertaining to existing adverse physical conditions in the immediate neighborhood within a 1 mile radius of the property, which are actually known by the broker, which cannot be discovered by buyer upon diligent inspection of the neighborhood or through review of reasonably available governmental regulations, documents, records, maps, and statistics. That would be things like there's a drainage issue in the neighborhood. There's perpetual leaks that everybody in the neighborhood and the HOA and residents know of that are happening throughout the neighborhood underneath people's driveways regarding their water mains. There's sinkholes. There's, something that unless you were in the know in that neighborhood, you wouldn't necessarily know about. An old cemetery that's overgrown that is in the neighborhood. We run into that a lot It's not, there's no way you would see headstones. There, it's so overgrown, nobody would know about it. It's not on any map. Those are the types of things that once you're aware of them and they're in a mile radius of the property, you would have to disclose those things, even if your seller is not disclosing them, and you would need to disclose it in writing. So very important that we keep that in mind. Any comments or questions, any scenarios or stories anybody wants to share about kind of things they've run into? David, I know you've got to have a story somewhere.
Not coming to my mind at this moment, Angie.
But are you guys seeing, I mean, I know you're seeing this because it's been around, it got really, really bad. It got really bad in the post-recession time when we had a lot of foreclosures, where suddenly you had these entities such as banks, Fannie Mae, Freddie Mac, what have you, that owned properties, and they own them because of the fact that someone defaulted on a loan. So they would have these extensive addendum packages that would attach to a contract that says, we are not disclosing anything. It's sold as is. We're not providing disclosure because obviously we don't know anything because, we only own this by default. We've never even seen this property. Well, that is fine initially, but as material knowledge is obtained through things like home inspections, I don't care if you're Bank of America or if you're Fannie Mae or Freddie Mac, once you obtain material knowledge of defects, you must disclose, whoever you are or whatever you are. Amy, I see your hand up.
Yeah, the 1 mile away is throwing me. Like, I mean, a mile away from me, there's a low spot and there are apartments that flood. Like, is that the kind of thing?
Again, when in doubt, disclose. And so it's it says within a 1 mile radius
That's like
of the neighborhood.
okay.
But only if you know, you know about it. You can't disclose and are not
Right.
out having to do research. A, you have to know about it. And B, it has to be something that someone would not know by reasonably looking around. For example, if there's a prison within a mile radius of the property, that's not hidden. If it's a landfill,
Okay.
that's not hidden. If it's power lines that people can see with their eyes, that's not hidden. Those things are not hidden. A waste management treatment plant, not hidden. Those are the types of things you would not have to worry about because they are absolutely not hidden, and a buyer has a duty to inspect that. Flooding issues that could potentially affect the neighborhood or the mile radius of the neighborhood that you would have actual knowledge of, it would just be best when in doubt to disclose. Because when you do that, you throw water on the fact that somebody can actually make a claim that they were damaged later because you didn't disclose. You're putting the ball back in the buyer's court saying, here's this information, buyer, do with it what you will. Make an informed decision. We're not bamboozling you at all.
Okay.
Hey, Angie, it's Joni. How are you?
I'm good, Joni. How are you?
I'm great. So, our particular neighborhood in phase one, we had pipes that were installed that within 5 years, pretty much every other house started having pinhole leaks coming through. And it became a big deal. It became a big deal when I started selling homes. Everyone moves every 3 to 5 years. And having to disclose that was tough because there were a lot of very unhappy people but not wanting me to disclose because it's our neighborhood. Yeah. So
Right.
it can get tricky.
It absolutely can. I went in my previous house, we had repeated leaks. It was a townhome community, and we had repeated leaks in our neighborhood. And it was everybody was chasing leaks after leak after leak, and it was only a matter of time before it was going to be someone's turn. And so, if a defect has been resolved, if somebody has, if there has been, this is just kind of like an aside, let's say there was a defect, like a leak or leaky pipe or something, but it was resolved. Under Beretta, you don't technically, and neither does the seller, have to disclose something that is no longer a defect. However, if it's something that was recently fixed, the smartest thing I can advise you and you to advise a seller to do is disclose recent repairs of defects. Why? Because we've had this happen where a seller, a couple of times over the years, where a seller fixed a leaky pipe, for example, and then as soon as the buyer closed, the leaky pipe failed or the repair failed. And had the seller said, this was a defect, this is XYZ plumbing that we hired to fix it, this is the steps they took to fix it, then that would have put a burden on the buyer to investigate that repair and investigate, to make sure that they were satisfied that the problem was taken care of. And it could have potentially saved the seller from being liable. But the fact that the defect wasn't disclosed and the repair that the seller did wasn't disclosed ended up costing these sellers some money. And so it would have helped a lot if those had been disclosed, that, hey, this was a defect that got fixed. And I'm just, in all transparency, telling you, this is what we were aware of and this is what we did to remedy it.
Would you recommend for best practice to include those kind of repairs, warranties, and receipts within your lookbook attached to your seller's property disclosure? Does that
The more you can disclose, the better. Whenever I sold my house, we had just done some renovations and we did a thorough list of everything that we had done. We said, this is the year we replaced the HVAC. This is the name of the carpet we used and the installer. This is the name of the flooring people. This is the roofing company that did this and did that. So, yeah, I mean,
okay, that's really critical.
Very, very beneficial.
One more quick question. If you go under contract, you have the inspection, the deal falls apart, but you have 50 pages on that house. You have every detail from light switches to leaky toilets. Does that become part of the seller's property disclosure?
It's not a part of the seller's disclosure because you don't want it to be, because the seller's disclosure is arguably going to be an exhibit to the contract and you don't want to ever make an inspection report and exhibit to the contract. But Your seller has promised, and you and the seller both statutorily obligated to disclose all of the information from it. So what I used to tell my my listing agents that were listing Fannie Mae, Freddie Mac, FDIC properties, Bank of America, whatever, I would say, deliver those inspection reports to the next buyer. So it just depends on how nitty gritty it is. The seller either needs to meticulously go through the seller's disclosure. They have to fill it out. You can't, but you need to proof it and make sure they haven't missed anything, and redo their seller's disclosure to add all of the now known defects and revise it, or you need to actually give a copy of the report. And it's so funny to me because agents will say to me, but we don't own the report. I'm sorry. This is information, and that information was given to you as a part of a transaction that your seller was the other side of. And now that information is information the seller needs to share with someone else. And I don't care who paid for it. It's information. And you can absolutely give it to the next buyer.
That's interesting. I've gotten burned on that one a couple of times because they said that's my proprietary because I paid for it. So thank you for that.
No, I mean, it's information, and they can't tell you can't give information. And the seller has a duty to disclose all that content. So,
right.
Yeah.
Thank you for the clarification.
Sure.
Hey, Angie.
Yes, David.
Just to be sure, because I was writing an email as y'all were discussing that. So my buyer pays for a home inspection. Just for good practice, I've always said, ask permission to share this, when we're requesting repairs, but you are stating we do not have to do that. We can send it because we have that information.
Oh, I want you guys, I'm so glad you brought that up, David. I want you guys to always, always, always deliver that inspection report. It's not a part of the contract. You should not reference it in your ATAC or your amendment to address concerns because you don't want it to be an exhibit. You would actually have to create the amendment to address concerns so that it stands on its own 2 feet and has actual command language in it, like seller to replace exterior lower rotten trim on front bay window with like materials and caulk and paint to match, blah, blah, blah. You have to be that specific in your ATAC when you're asking for the repairs, but do not go to the extent of referencing any portion of the inspection report in the ATAC, because then that can cause the lender to be required to actually see it, because in essence, you're making it an exhibit. But do you deliver it? Every single solitary time. And you don't ask an agent whether you can deliver it, you deliver it, and then you explain to them that when you're in these negotiations and they're saying, oh, well, somebody, we might not, you know, go under contract and I didn't open it or what have you. This is why I want you guys to be aware of this page here. This is in section C of your purchase and sale. This is the notices paragraph. As soon as you deliver it to an agent, it's not only considered delivered to them, but to their broker, as well as to their client, the seller, even if they don't open the attachment. So I want you guys to send it, because that's where you get most of your leverage. If we go away because we can't resolve this issue of the defect, guess what's not going to go away? Sally Sue, listing agent, this defect's not going to go away. Neither are the other 50 pages of content that now you guys are responsible for disclosing.
Right.
See how that gives you leverage?
Yeah, so my particular situation, based for, my question, we didn't necessarily use that form. We used, an amendment to the purchase agreement. And whatever we stated, it was listing agent would come back. Okay, well, I want to see the inspection report then, if that's what you're asking. And so that was the scenario where I would ask, hey, Mrs. Buyer, you purchased this, I have permission to share this. So, but again, you're saying we don't have to ask permission once we have
Well,
that.
I mean, obviously you are representing the buyer. So I would coach my buyer. This is what I would do. Say, this is our absolute, the purpose of getting this inspection is to try to find out for your information what the condition of the property really is. No one's going to take our word for it as to what the condition of the property is. And the most maximum leverage we can get to try to get either to negotiate repairs or negotiate other concessions, like an increase in closing cost contribution from the seller or a price reduction. The only way we're going to get that leverage is to show them all of the findings in this report. That's the purpose of that report. It really is not using the report they paid for if they don't deliver it. And I would educate my buyer client on that. This is the purpose of the reason you got this report, to use it as leverage to negotiate that which needs
I've never
to be
had
done.
any pushback from it. I was just making sure I understood that if we wanted to, we have the information, so we technically don't have to ask to share it.
Right. But I would prepare my buyer that this is the whole reason we're doing it.
Correct. I understand completely. Thank
And
you.
that if we can't work it out, we're going to remind Sally Sue, who's my fake villain, the listing agent, that if we go away, the problem's not going to go away. And now they need to disclose. And if the seller won't disclose, that they have to disclose under Beretta. Susan, I see your hand up.
Yeah, thank you. And I'm hearing you say that on the ATAC, we should not list the page number and photo
Right.
for what we're asking about.
Correct. Put that in a separate email, and describe, think of your ATAC. It's going to be a part of the contract. And by the way, I have to say this because this is another very bad practice and big misunderstanding. There is never, ever, ever a time where a lender is not supposed to get all parts of a contract. If anybody ever tells you that the lender doesn't want to see that amendment, or that you need to create a separate numbering or lettering system for amendments, that some of the lenders and some that they don't, that person that gave you that advice has just told you to commit a felony and to commit mortgage fraud. So the lender always see that amendment. And while you can always send the inspection report, and you can even email and say, a key, if you will, section 1 on the amendment, item 1, see page 8E of the inspection report. You can send a key to the agent to help them maneuver through it. But when you actually reference that page and everything in that actual amendment, you then are causing the underwriter to have to see that inspection report.
Okay, That is
And you're
very helpful
making
to
it, in
know.
essence, an exhibit. Another thing you never want to put in an ATAC or anything regarding repairs, if somebody is negotiating instead a change in price, you just put sales price to be blank. Boom, that's it. Seller to at closing, seller to contribute a total additional $5,000 towards purchaser's closing costs for a total contribution of $8,000. One thing you never want to state is the phrase in lieu of repairs, because if there are no repairs being agreed to, you don't need to mention them. What's being agreed to is the numbers and the math. Instead, you don't want to write in lieu of repairs. Again, that's a red flag to an underwriter. You're not committing fraud. You're simply saying, and again, the bank is like, listen, we don't really want to see these inspection reports, but if you guys go making them attachments to the purchase and sale and referencing them, you're forcing our underwriting team to have to ask for it.
Okay.
Another thing to avoid when we're talking about repairs is gosh, what was I going to say? I lost my train of thought. But when we're doing the ATAC, we don't want to state in lieu of repairs. And there was something else I was going to suggest to you guys not to write in there. Oh, certified or licensed when it comes to describing the vendor. So when you use the term certified, you're talking about a piece of paper. And I will tell you guys, most of the time, the profession that you're referring to as certified doesn't actually have any such certificate. And you got to remember that Pete the plumber or Ed the electrician are not parties to this contract, and they never signed that amendment agreeing to provide their license. So avoid licensed and avoid certified or anything that's referencing a document that the vendor doing the job has to do. You could use the word professional, or if you're really concerned about it, you can state the actual identity of the company that's supposed to do the work. You know, it's going to be Superior Plumbing, you know, needs to have Superior Plumbing or so-and-so septic services complete the work. So that's a good way to actually have control over it. But just using a random generic term like licensed or certified, we see that also being problematic. And again, lenders have said this to us. When you guys do that, they're like, okay, great. Now we need to see Ed the electrician's license, because you said it has to be a licensed electrician. Well, Ed the electrician's not going to return anybody's call. He's busy working. He doesn't care. He's not obligated to give anybody a copy of his license. So, you know, that's kind of the problem.
Thank you. This is so helpful.
Oh, I'm so glad. I'm so glad. Sorry for the technical difficulties at the beginning. Any more questions or comments? Tom is teaching Contracts 101. I think he's teaching part 4 today, which is going to go over the amendment to address concerns and what have you. So if you guys want to tune into that, that's at 1 o'clock. Tom will be teaching that on the same link. Want to take a little break and then join Tom. Let me also quickly look here at the chat. Let's see. I think we've also got a copy of the presentation here. So, Joni, I think I might have answered your question, but you said when inspection is done and it falls out of contract, the entire inspection. Oh, I think you already asked me that question. Thanks, Barbara. I appreciate it. So yes, Joni, I think I've already answered that, but either give them the entire inspection report or have the seller with you wordsmithing it and proofreading it, update the seller's disclosure to include all the now known defects. You know, and if they do fix anything, then I would disclose that you had a defect. This is the company you hired, and this is the steps taken to fix that defect. That's just the smartest thing you can do to protect a seller, and the seller can do to protect themselves. So,
hey Angie, it's Naruna.
Yeah, Narona, how are you?
Good, how are you?
Good.
Quick question regarding the seller's disclosures and work that the seller has done to the property that needs to be disclosed. So is there like a dollar amount that triggers the work to be permitted? How can you clarify, elaborate on that?
That is something that the seller and you would have to check with the planning and development. It's not so much dollar amount. It's, are there walls being moved? There's going to be regulations in each county and each city. So it would be a very important for the seller to disclose. But if you have an unfinished space, for example, and they finish it, that's typically going to need a permit no matter what. And so that's probably one of the most common things. Cosmetic repairs such as like new flooring and things like that, not necessarily going to need a permit. New countertops, not necessarily going to need a permit. Moving walls, finishing unfinished spaces, things like that. This is going to be something that calling the planning and development department, the issues building permits would be a good fact-finding thing for you to find out. But generally, I can tell you right now, if the county sees a space is unfinished and you didn't pull a permit, then the county still sees it as unfinished. And why is this such a big deal? Because when somebody buys it, they inherit that problem. And if the county then later finds out that that was finished without a permit, they could actually cause all of that work to be ripped out. And that's going to financially harm the buyer that bought it. And that is where lawsuits are born.
Gotcha. So depends on the county and the regulations. Got it.
Right. But your typical unfinished space being converted or any type of use when somebody's moving walls or they're changing bedroom structures, they're making a dining room into a bedroom, they're adding a bathroom, anything like that that's going to change walls or the number of bedrooms, number of bathrooms, a finished space into an unfinished space, things like that. Generally speaking, that's going to require a permit.
Gotcha.
And it needs to be disclosed.
And the key thing you said, I got it, is the seller has to disclose, but the seller doesn't need to fix it. Yeah, so I think that's the key.
They have to really transparently disclose it. There's a section in the seller's disclosure statement which asks about that, and then I would actually recommend that not only do they check the box, yes, there is some unpermitted work, but then there's an explanation blank at the bottom of that paragraph, and they need to explain exactly what they did. And again, that way you're putting the burden back on the buyer, saying, buyer, you're making an informed decision. If you like all the finishing that they did, then you think it's great and you are aware that it wasn't ever permitted, but you love the house and you think it's great, you can buy it like that. But we're just being very honest and transparent with you. So if this ever blows up, we did our part by disclosing it.
Gotcha. Thank you. That was very helpful. Appreciate it.
Tammy, did you have another question?
Yeah. So I'm sorry, what's the best way for us to know if they had work that's permitted?
Development, call the county department that issues building permits. It's typically going to be planning and development, and sometimes it's affiliated as a part of the zoning department.
Angie, can I add on to that?
Oh, absolutely.
I actually had one of my transactions stopped by the mortgage company because it was disclosed that there were improvements that were not permitted by the county. And at that point in time, there was nothing that we could do other than, as you stated, to have it torn out and permitted properly. And so it stopped our transaction, and my buyer, we had to find them another house.
That's right, but that's because it's so serious, Barbara, that the county could condemn a place, and they could actually, like, if somebody builds an illegal addition, they could tell them to rip the entire addition down. I mean, the liability of selling something like that. And I know that there's a lot of people out there taking single family properties and making them into illegal duplex. And I say illegal. Yes, I said that out loud because that's what's happening. The county zoning, it's all related to zoning because zoning says this area, this neighborhood, if you will, is zoned single family residential. And you can't go in there and make it multifamily and create an apartment. If you want to do a finished basement, fine, do a finished basement. If I'm gonna list a finished basement, I'm gonna find out if it's permitted or not. If it's not permitted, I'm gonna disclose that. But if, let's say if it was permitted and the permit allowed for a kitchen and a bathroom and all this other stuff, just because a seller wants you to then describe that finished basement with a kitchen and a bathroom and a bedroom, maybe it was permitted. They want you to describe it as an apartment. Well, when you're listing it, this is not a multifamily zoned property. It's a single family house with a finished basement and a kitchen and a bathroom. Okay, so we've got to be careful that we're not harming the public by describing something inaccurately against the law.
Right.
So,
Because
so
this was
we have a lot of investors out there going out there, and it's nothing new, but it's becoming in certain areas real popular right now. We have a lot of investors going out there and taking single family houses and turning them into multifamily. And oftentimes this is not done with any kind of knowledge of the zoning department or any kind of legal permitting. And again, that has to be disclosed. If the agent listing that has knowledge of that, they have to disclose it. And if a buyer wants to take that chance and say, hey, this is a great investment and I love what they did here, and they want to take that chance, fine. They just need to make an informed decision. Any more questions, guys? This was kind of a short presentation, but it was something I really thought that we needed to talk about. Broker support, broker@heartatl.com. Anytime you guys have any kind of question, obviously you can reach me and Tom on our cell phones, text us, direct email us. However, we're here, and you guys can always reach out whenever you want to run something by us.
Angie, you said we'll get a copy of this?
I'm sorry, I can't. Is that you, Barbara?
Yes, I was asking, will we get a copy of this?
In the chat, I believe that if you a link, I can also email it to you. I believe it got posted in the chat. So look in the chat, and I believe it's yes, it's been posted. But I'm gonna go. I can also just email you a copy of the PowerPoint.
Okay, thank you.
All right, guys. Well, Tom's coming up in about 12 minutes to teach Contracts 101 Part 4, where he's going to be focused on the amendment to address concerns and terminating and due diligence and that sort of thing. So I will see you guys probably in a week or so. One of us will be teaching contracts next week. So stay tuned, and everybody have a fantastic day.
Thank you, Angie, again.
Thank you.
Thanks.